fact constitutional under the Fourth Amendment of the United States Constitution. Your Honors, the Fourth Amendment states that an officer is able to take someone into custody when they have probable cause. Your Honor, the state statute is in fact constitutional because when the state statute is invoked, the officer already has the probable cause that they need to make the arrest or to hold the suspect in custody.
So, Mr. Winston, you may have been privy to some of the discussions we've had with other attorneys. There's certainly a difference between custody and death. In this situation, Mr. Varner wasn't taken into custody. He was clearly seized. He was permanently seized. Help us draw the distinction between the guy who steals the pack of gum, running down the street yelling, I'm not armed, but runs, doesn't want to stop, doesn't want to go to jail, and this situation. Where do we draw the line that saves the statute, if the statute is salvageable?
Yes, Your Honor, I think that is a very good point. But as we saw in the case of Mullinets versus Luna, the courts ruled that a suspect who is fleeing the police in the case of a dangerous car chase, they found that the police using deadly force in that matter is constitutional. And one thing that it is important for us to realize is that when a law enforcement officer tells a suspect that they should freeze, that they should stay in place, that it is up to the suspect to follow the instructions of the law enforcement officer.
But Counselor, does that case really control in this situation? It sounds like the facts are very different, right? In that case you just cited, whose name is
Mullinets.
Yes, Mullinets. That was, we knew that there was a suspect fleeing at rapid speeds, very dangerously in a car, which could potentially kill, God knows how many people. The facts in this case are very different, where we have an unarmed suspect without any sort of weapon comparable to what an automobile can do. So should that case even, should that precedent even carry over to these facts?
Your Honor, I would disagree with that point because in this case, the officer did not know that the suspect was unarmed until the officer already had the suspect in custody. And at the time when the officer used reasonable force, they saw a shiny object in the suspect's hand that they believed was a weapon. If the officer allowed the suspect to continue to flee law enforcement officers, then similar to the case of a criminal being loose in a car that can cause a number of harms, a suspect fleeing on foot with a weapon could have been just as deadly as someone in a car.
But there is a distinction here, and I think you kind of hit on it, was that first suspect, we know he had a car. We know if ands or buts about it. The officers knew that. By your own admission, the officer didn't know whether the accused in this case had a weapon. She thought he might, but there's a difference between those two facts. Shouldn't we treat those under two different standards?
Well, once again, I would have to disagree, Your Honor, because if the officer's goal is to protect the law-abiding citizens who are in the community, and therefore the officer should not play a game of chance and assume that the suspect is unarmed when the officer sees something in the suspect's hand that they believe could be a weapon and could be used to harm others.
A very interesting choice of words you use, play a game of chance.
Yes.
So is it the citizens in this game of chance, as you pose, the wages of defeat is death?
I'm not sure that I understand your question, Your Honor.
You said that police officer should not engage in a game of chance,
Yes.
where there's a chance the person might not kill somebody, or a chance the person might have a weapon and kill somebody. Well, in that hypothesis, are we going to have a statute that is so vague that anybody running with a can of soda or a pack of chewing gum that they stole, or a homeless person, or anybody who just have trust issues with law enforcement, when they flee, the police officer can shoot?
Well, Your Honor, I would like to also point our attention to the case of Payton versus New York, where the courts found that the officers should not be inhibited on what they are allowed to do based off of the suspect's illegal actions. So to
Are you
directly answer
familiar
your
with
question-
Garner v. Tennessee?
Yes, Your Honor.
Distinguish that case for me.
So in the case of Garner versus Tennessee, the police officer saw that the suspect was unarmed. The difference between that case and this case is that the officer had reason to believe that the suspect was armed. Additionally, the officer told the suspect to halt in place so that they could get the suspect into custody without using deadly force. The suspect continued to run. In Your Honors, we have no reason to believe that the suspect was inhibited based off of sight or hearing. So we have every reason to believe that the suspect heard the officer tell them halt. And I would also like to address the point that you made earlier, where you said it could be a homeless person who has reason to not trust the law enforcement officers. In this case, this was someone who was familiar with law enforcement as they were a member of their high school's mock trial team. So they were very familiar with the law, they were very familiar with law enforcement officers.
Must have been an upstanding person.
And Your Honors, I would also like to make the argument that it is not the role of the court to assess whether or not laws are moral or not. Your Honors, we have to look at previous rulings, and we have to use those rulings and take them into account when we're looking at the facts of this case.
Counselor, that's true, to a point, but that's for this court to decide whether the laws are constitutional or not, and whether they're moral, correct?
Yes, Your Honor.
So if we believe that this law is unconstitutional, we can't uphold the lower court, and we can find that way. We can even overrule the McMillan or Garner if need be.
Yes. And Your Honor, I do respectfully ask that you all do overrule the rulings of the lower court, because this statute is constitutional under the Fourth Amendment, because as I stated earlier, when it is invoked, the officer has to follow the
Counselor,
laws.
let me ask you
Yes.
this, which I think is the crux of the matter here.
Yes.
Do you think the law, as it is stated, is specific enough, narrowly tailored enough to not infringe upon the rights of citizens' life, liberty, and property without an unconstitutional siege? Because right here, we have a person who, based on assumption of police, kills and seizes them on this assumption. And this law, we're trying to figure out if it's clear or not to give not only the police, but citizens the rights that are due to them under the Constitution of the United States. So you understand my question?
And to clarify, you're asking if the
Law is-
statute is clear enough for us to be able to assess whether or not it is constitutional under the Fourth Amendment.
Yes.
I would say that yes, Your Honors, it is clear enough for us to be able to know that it is constitutional under the Fourth Amendment, because it allows law enforcement officers to not exceed the power that is given to them by their uniform. The power that is given to them by their uniform is the power to protect and serve the citizens of the United States. Now, Your Honors, I would recommend that after this case, we do go out and we lobby our lawmakers and ask them to create a statute that is more specific, so that we do not continue to have.
Can we just rule against it and make them do it?
Well, Your Honors, the reason why we should not rule against it is because this statute is supposed to protect, and it does protect the best interests of all law-abiding citizens. And the reason why it is not unconstitutional is because it does allow suspects to have probable cause if they are seized.
Okay,
So-
let me, Mr. Winston, are your other
Yes. I-
colleagues,
Yes.
okay, we're gonna, even though we're out of time, we're gonna give your colleagues an opportunity to make their presentations.
Yes, thank you, Your Honor.
Thank you very much, Mr. Winston.
Your Honors, may it please the court, I'm Naomi Ray, and I will be addressing the second issue in this case on whether or not the state committed an error when they determined that the state statute was unconstitutional under the 14th Amendment. Judge Attorney determined in Roe v. Wade that if a state statute is narrowly drawn to express only legitimate state interests at stake, then it is constitutional under the due process clause of the 14th Amendment. And in this case, well, in this statute, the legitimate state interest that's at stake is the public safety of members of the surrounding community. Burglary is a gateway crime. Most burglaries, after they're committed, it leads to other crimes and other assaults. So when the statute is allowing the police officer to use whatever force necessary if the suspect flees or resists arrest, the state is protecting the other individuals of the community when they do this law.
Counselor, we've heard for 50 years that marijuana is a gateway drug. So would the same analysis apply there? Would a law that says that an officer is allowed to use deadly force against someone suspected of carrying marijuana? It sounds like your analysis would say that's constitutional.
Wait, to clarify, you said marijuana is a gateway drug to crime or just a...
Well, a gateway drug to other illegal, well, yes, we could say crime or we could say other illegal drugs.
And you're asking if it's...
And it's the same as the scenario you just said. You just said that there's, burglary is a gateway crime. So I'm assuming that's the justification of the important interest here. So if we flip this and say, well, marijuana is a gateway crime, does the same analysis still apply?
Yes, because there are, this minor is saying that marijuana is not legal everywhere now, and that there are, when people, what's illegal, so I think that state statutes that, well, if there was one in place for the marijuana, if a person flees or this, if they have marijuana, then the police officer should be able to use necessary force.
Ms.
Because
Ray,
it is,
I didn't mean to interrupt, I thought you were done.
because it is a threat to the safety of other individuals.
The statute that you're defending and asking us to address and reverse the 12th Circuit on, as I read it, would authorize an officer to use deadly force against someone who is wearing bandoliers, carrying a gun in each hand, and saying, I'm going to kill everyone I see. Stop. Police can use force on that person. One extreme. Other extreme, I'm going to be boring and repeat myself. All I have is a pack of gum. I stole it. I'm not going to pay for it. I'm unarmed, but I'm not going to stop for the police. As I read this statute, the officer would be justified after saying, I'm a police officer, stop, you need to stop, in using deadly force to apprehend both those people. Do you agree?
Okay, so for non-violent and violent crimes, the other side may argue that the statute should not be, well, is not constitutional for the non-violent crimes, but in Garner's case and in Garner, the officer in Tennessee v. Garner, they could not see that the person had a weapon, and in other crimes, when we make laws, it's hard to predict what will happen in the future. So you have to assume that those cases will happen, but it's up to lawmakers to make laws that will protect other people.
But isn't the issue that the non-violent folks are still subject to being shot by the police if they choose not to stop? And that's the concern here.
It is an issue that the non-violent perpetrators can be shot, but the law is looking at protecting other individuals. And as Alvin Winston said earlier, it is up for revising, but it is constitutional under the 14th Amendment because it is protecting the health of the community members.
Here's what my colleague is trying to ask Counselor, objectively reasonable. Is it objective for an officer who does not know for certain whether a person has a weapon or not to make the assumption and shoot a person dead versus this statute that